Okay, this is one of my boys, Richard. I was communicating with Richard and provided Richard some materials and passed some emails back and forth with Richard. Richard did great today. There's some openings he missed, and just wanted to go over that. It's not a criticism, Richard. I think he did phenomenal. I mean, listen, when you're there in front of these people, it's tough to do what he did today. But I just wanted to point out that it's easy for me to look at it, stepping back, because I could pause it and catch little things. But I just wanted to point out, because everyone likes these role-playing things. Let's take a look at some things that maybe he could have done and may have thrown him off a little bit. But like I said, but all in all, man, he did phenomenal.
Mr. Richard Arterburn's case,
Oh, yes.
cases
Are you
with
there,
Miss
Mr. Arter?
Elsie Craven.
Ms. Craven, are you with us?
Yes, Your Honor, I'm present.
And there's
Hello,
Mr. Arterburn too.
Hello, Your Honor. How are you doing?
I am well, thank you. And I don't know how much and how recently you have talked with your lawyer, but somewhere along the way, and I'm talking probably a couple months ago, there was a concern that you might not be competent to stand trial, meaning that you didn't have a clear understanding of the charges and the roles of the people in the court and your rights. But I don't know, I don't have any personal knowledge of that. Do you have an opinion about that, sir?
Sir, my name is on special deposit with the court for future return on my interest. I reserve all my rights and remedies, and I waive none ever.
All right, that first part, that's a lot of that's not me. That's he's blended some stuff he's learned from some other people, a lot of people that have been on Crow. The only thing I do recognize when he states that I reserve my rights and I waive no rights ever. So that's very important to do when you're in front of these people, because these people will actually assume that you are waiving rights when you're not waiving rights. So you want to establish like, hey, I don't ever waive rights. I don't waive rights ever. So he did real good there.
I am the beneficiary of this case today. Does the court have any evidence that I am not the beneficiary?
I don't have any evidence at all. We're not having an evidentiary hearing.
Then for and on the record, the court admits I am the beneficiary, and as beneficiary, I appoint the court as trustee to settle this matter.
Well, I'm not agreeing to that appointment, but again, I am obligated under the law to be sure you're competent. You sound lucid. I would assume that you understand how our system works, even if you don't believe you should be subject to that system. Am I correct?
All right, so that's definitely not my stuff. He's getting into trust law stuff, but he's letting the judge know that he knows this little scam going on with the old cap's name, and the judge knows exactly what he's talking about. That's why the judge said you sound lucid. He knows that he knows the game. Now this is a competency hearing. This is one of the things they'll do to you. That's one of the things he was telling me. He said, they keep pushing me for this competency hearing. They're saying I'm incompetent, and this is what they do. The more you start kicking their ass and exposing them, they try and tag you as being incompetent. Because God forbid you just smoke them. So they try and tag you as being incompetent and that, you need mental evaluations. And when you start hearing that stuff, you have them. But the only thing here is like this guy, the judge, he sounds like a decent guy. Listen, he knows that Richard knows the game.
Yes, sir. I do understand that how your system works, but if the court believes I am the surety, I demand my rights to subrogation and all of the collateral securities. I would appreciate a check by the end of today.
Now, what he's doing is he's telling them that, listen, he's stating that he's the beneficiary. And it's sort of the same thing I'm doing. When you go in there and you file affidavits of status stating that, you're the man or you're the woman, you're basically stating that you're the beneficiary in this matter. And he's letting them know, listen, when a hearing happens, something like this, this has to be bonded. In other words, whoever brings this hearing, who brings this matter before the court, they've got to insure it. And what he's asking for is, hey, he's basically trying to claim their bonds, is what he's trying to do. He's trying to claim because the party that loses, they're responsible for those bonds. So what he's trying to do is actually call in their bonds. And the judge knows that, and you can see from the judge's response that he doesn't give him a response like what are you, crazy, man? I have no idea what you're talking about. He just basically says, well, I'm not going to agree to that. Not that it's not there, not that it's not happening. He's just not going to agree to it.
Well, no, I'm not going to agree to that today or any day. But the reason I'm asking you about this, sir, is because if there is a concern that you're not competent to stand trial, and you may end up going to trial against your wishes. And you may, if you choose, voluntarily absent yourself from that trial. Nevertheless, you could end up being under the jurisdiction of the court, whatever the result of the case. Do you understand?
Listen to his language. May, could, may, could. These are not definitive statements. He's basically telling you may or could that they don't have jurisdiction. Even though he's going to claim they have jurisdiction, and we'll find a way to challenge this when when we get to that part. But he's just he's talking in vagueness. This may happen, that could happen. Well, yeah, I could hit the lottery tomorrow, So he's being very vague and very coy, basically.
Sir, I am never under the jurisdiction of the court, seeing as I am the beneficiary.
Okay. Well, we're going to differ, I guess, and I don't know what else to tell you about that. But
see, when he says we're going to differ, I guess, but I don't know what else to tell you with that. So Richards, again, he's stating that I'm the beneficiary. It's the same thing you're doing when you're saying I a man or I a woman. You're basically, even in trust law, you're basically telling them that you are the beneficiary in this situation. So what he could have said to the judge when the judge said, well, we can beg to differ, he should have said, well, sir, what evidence do you have that I'm not? Put the judge on the spot. Because the judge is basically making definitive statements here. The judge, in a way, is sort of litigating this matter because he's already making legal determinations about Richard. This is supposed to be a competency hearing where he's determining his mental faculties, but this judge is making determinations on legal determinations here. So one thing I would have done basically here is just basically throw it on the judge and state that, hey, I'm sorry, because the judge is saying, well, we beg to differ. Oh, excuse me, sir. What evidence do you have that I'm not the beneficiary? And I would press the judge to give me an answer. So that, hey, the judge is stating he's got a position. Great. Make the judge support his position.
the reason I'm telling you this, if there is a concern on anyone's part, and I'm going to tell you honestly, after talking with you, except for your belief that you're not subject to the jurisdiction of this court, as is usual in cases like this, I think you are competent.
I think you are competent. So this crazy man that they thought was coming in, and he's talking all this crazy trust stuff, and he's basically talking about, you'll see him get into talking about, I'm not the surety. Evidently he does know what's going on. So the judge knows, he knows the scam, he knows the system. That's what the judge is saying. Listen, this guy is competent.
Yeah, unless the prosecutor or the defense attorney or anyone else tells me that they don't believe you are competent, I'm going to believe that you are competent.
Right there. Objection, sir. Remember, these are attorneys. These attorneys he just referenced, the prosecutor and all, they have no jurisdiction over Richard. They have they have no standing in this matter, meaning that Richard has not damaged them and harmed them in any way, so they have no standing to be involved in this matter. And they definitely don't have any subject matter. I mean, they don't have any personal knowledge of any matter involving Richard. In other words, they're interlopers, the parties he just mentioned. And first thing the judge is saying, well, if these people have this to say, oh, objection, sir. Those people have no jurisdiction over me, no legal stand in this matter, no personal knowledge in this matter. I'm going to forewarn those people to stay out of this matter, or I'm going to have to move court against them when I go on the offense in this matter. So I would sort of back them off right away and let them people know, you people stay in this matter. I'm going to pull you guys into this matter.
The reason I bring that up is because if it should happen that someone believes that you're incompetent, you will need to be examined, and you'll need to submit yourself to an examination by a doctor. And
objection, sir. There's no man that can make me submit to an examination, sir. That's a ridiculous claim. On what factual basis are you basing that claim? I mean, this is stuff you have to call them on, because what he's doing, he's sort of trying to assert that he has power to do certain things to Richard. That's what that is. It's sort of a feeler he's throwing out there. So what you want to do, basically, objection, sir, because listen to the words, you will have to do this, you will have to do that. Well, first of all, this court, from what I'm seeing, Richard's already stated this court doesn't have jurisdiction. The judge is saying we do. That's one of the things I would have called the judge on right away when I said, sir, what evidence do you have that this court has jurisdiction? And I would have led the judge down that route and made him give me answers, because courts can't act without first personal jurisdiction, and they need subject matter jurisdiction. And there's big flaws in any kind of case where the state is involved, because in any matter a party has to have legal standing in a matter, and I'm sorry, a corporate fiction can never have standing because it can't be damaged, and it doesn't have rights. It can't have a right violated. So this court, I know this court doesn't have subject matter jurisdiction, and they don't even have personal jurisdiction in this matter yet. So that's one of the things Richard should attack.
I'm hoping that you will agree to submit to that.
I'm hoping that you would agree. So the judge is telling you right there, listen, I don't have any power to order you to do anything with like an examination. I'm hoping that you would agree. Gee, I'm hoping that you would cut your hand off. I'm hoping he would cut your leg off. He can hope all he wants. He's telling you right there that he doesn't have the authority. They can't demand you do anything, any such thing like that. Like, submit yourself to a mental evaluation.
Examination. Should it happen?
Should it happen?
Now, if it's not going to happen, we're all good, and then we'll deal with our other conflicts later, right? But if there is a concern that you're not competent and you refuse to submit to an examination, I hate to do it, but you'll be taken into custody, and you'll be held in custody until you do submit to an examination in jail.
Objection, sir. And what would be your probable cause for taking such an action, sir? Under what authority would you be allowed to take such an action? What's the probable cause, sir? Excuse me, am I your property? Do I have a contract with you? Then under what authority are you claiming you're going to force me to do something and put me in prison if I refuse to do something? I'd put the judge on the hot spot there. I'd put him on the defensive, and you do it with questions. Sir, under what authority are you moving? You're making these crazy, wild claims, and what's your probable cause? Because basically you're stating, if you could do something to me like that, then I have to be your property. This is not a jurisdiction thing we're talking about here. He's actually claiming that sort of Richard's his property because he's going to force Richard to do something. Well, that would mean like he's Richard's master and Richard's a slave, and he's going to force him to do something. Objection, sir. Under what illegal authority or would you take such an action? And please tell me, what would be the probable cause for such an action?
I understand what you're claiming, sir. I do not consent to any of that, and
I don't blame you.
and I am once again Jason Steen's the prosecutor. He has no evidence for any of these things. He had no evidence to file the motion. There is no witness in the matter of me for his claim. So how can he make that claim?
That's definitely stuff that we've talked about. We've got into it. That attorneys have no personal knowledge of anything. And so what's happening is you've got an attorney claiming to speak for a corporate fiction, the state. So the attorney's submitting motions. And it's sort of like the attorney's saying he's representing Mickey Mouse or Donald Duck, and he's going to submit motions for Mickey Mouse or Donald Duck. And Richard's basically calling him on the bullshit there. He's saying, yo, this guy, whatever the Steen, whatever the attorney is, he just said that this guy's got no personal knowledge of anything. A witness in any matter must have personal knowledge. So that means what Richard just exposed there is that attorney that submitted these motions into the court. Those motions are what are called hearsay. Because if you don't, you need to have personal knowledge in a matter, whether it's equity or whether it's judicial. You need that personal knowledge in a matter. That attorney that submitted those motions that Richard's referencing, he's got no personal knowledge of anything. And even in their twisted law stuff, you go check out the Trinsley versus Pagliaro, which is a Pennsylvania case, pretty famous Pennsylvania case. But it basically states that the pleadings of an attorney, though helpful, are not sufficient for summary judgment or a motion to dismiss. And what that holding's actually saying is the attorney's not a witness. He doesn't have personal knowledge of a matter to submit such things to a court. So Richard's basically calling him on the carpet for that. That, listen, this guy that submitted this motion for whatever the motion's for, he's got no personal knowledge of anything.
I have no idea. I don't know anything that he knows that I don't know. It's just under the law. If either party or any party believes there's a concern about competence, I'm just required to.
Objection, sir. And what evidence do you have that such a law, whatever law you're referencing, has anything to do with me? You're always going to challenge everything. Objection, sir, because he's talking about some law. I don't know what this law is. First of all, he doesn't name the law. And so what's the source of the authority of the law? So this judge is operating under this premise that this law, whatever he's coming up with, applies to Richard. But objection, sir. Well, first of all, objection, sir. Under what authority are you claiming that this law, that I have no idea what you're talking about, applies to me? Put the judge on the spot. Make him explain how their laws apply to you. Because like I said, there's only two ways a document can apply to you. Either you are somebody's property and they could just write things down on a piece of paper called a law and make it apply to you, or you have a contract with them. And I'm pretty sure Richard's not their property and he doesn't have a contract with these people. So I would attack that and take that away from the judge.
To inquire into it. But again, go ahead, Ms. Craven.
May I say something, Your Honor?
Yes.
I was appointed to represent Mr. Arterburn, and it was a mental health.
Objection, sir. Who appointed Miss So and So to represent me? First of all, who appointed her, and under what authority can they appoint people to do things for me? Again, we go back to the two basics. Then the people appointing this school marm that you're seeing there, they must be claiming that Richard's their property, and they can take this school marm lady here and make her represent Richard. So Richard would have to be their property, or Richard would have to have a contract with them that gave them authority to take the school marm and make her his representative. So objection, sir. You want to attack, you attack everything that they like. So we don't cede any ground. We don't give them any ground whatsoever. We challenge everything.
Appointment. Mr. Arterburn has not engaged with me at all.
Mr. Arterburn has, Richard has no, he don't have to engage with her. He's under, it doesn't matter who appointed her, nobody can make you talk to somebody else or deal with somebody else. Basically, what that would, in reference, what that would actually be doing by making him speak to her would be forcing him into a contractual obligation with this school marm here. Nobody can force you into a contract. It's total nonsense. So everything coming out of this woman's mouth, this woman's supposed to be an attorney, everything coming out of her mouth is absolute dribble.
I have tried on a number of occasions to talk to him about his case.
Oh, she's tried. She's done everything she can to talk to Richard. He just won't talk to her. Oh.
Who will agree to submit to that? Okay, well, we're going to differ, I guess, and I don't know what else to tell you about that. Believe that you are competent.
What you're claiming, sir, I do not consent. There is no witness.
So I lost my place here. I'm just catching up to
in
it.
the matter of me for his claim. So how can he make that claim?
I have no idea. I don't know anything that he knows that I don't know. It's just.
And I'm good. We went back to that point. The judge said, I have no idea, but he don't know anything. So let me get this straight. The judge doesn't know anything, and yet he's ready to set a trial up. Where what that means, if he doesn't know anything, then he doesn't have personal or subject matter jurisdiction. The court needs both personal and subject matter jurisdiction in a matter to move forward in any matter. And this judge basically just telling you, listen, I don't know anything. Well, if you don't know anything, then you can't prove that this court has personal and subject matter jurisdiction. And like I said, you need both. Without both, you have nothing. So that was an opportunity also.
Under the law, if either party or any party believes there's a concern about competence, I'm just required to inquire into it. But again, go ahead, Ms. Craven.
May I say something, Your Honor?
Yes.
I was appointed to represent Mr. Arterburn, and it was a mental health appointment. Mr. Arterburn has not engaged with me at all. I have tried on a number of occasions to talk to him about his case. I have a concern about competency because I was appointed as a mental health attorney, and he was identified as possibly having a mental.
They identified. Never let them do this they, we, us thing, okay? Who is they? Where did they come from? I want to know who they is. And who the hell are they to determine whether you're mentally competent to do anything? Does Richard get to walk around and state whether they're mentally competent? It's a ridiculous claim. Objection, sir. No one has authority over I, a man, to make such a claims, whether I'm competent or not. I mean, this woman, everything coming out of her mouth is complete dribble.
Health problem, and I do not feel comfortable going forward if a client could.
She doesn't feel comfortable going forward. I'm sorry. Do you have any standing in this matter, lady? Who cares how you feel? Who gives a damn how you feel? Oh, I don't feel. Who cares how you feel? You've got no jurisdiction in this matter, which means control. You've got no legal standing in this matter, and you've got no personal knowledge of anything regarding me, meaning Richard, in this matter.
Possibly be incompetent.
Mr. Arterburn,
Yes, sir.
to the extent you're willing to tell me, do you have a job, sir?
Objection, sir. Relevance. I would this judge wanted to poke around, and he actually did say to the extent you're willing to tell me. So he gave him an out there. What that was the judge actually giving him an out, because Richard could have turned around, which I would have said is objection, sir. Relevancy. No, there's no relevancy to whether Richard has. It doesn't matter whether Richard has a job or not. It has nothing to do with his mental competence. So objection, sir. Relevance.
Do I have a job? Because of COVID, I'm currently unemployed, but I have been previously employed since I was 16 years old.
What were you most recently doing full time?
Door to door.
All blather. This is an objection, sir. These are all things he should have shot down right away with the first question. Objection, sir. Relevance. I would have answered none of these questions.
Sales.
Okay. How long did you do that?
Over a year.
Did you ever get sideways with anybody along the way?
Did you ever get sideways with anybody along the way? In other words, yes, sir. One guy couldn't sell him some stuff, and I punched him in the head. Or I keyed his car. This is the fishing expedition that this judge is sort of going on. He wants basically Richard to self-incriminate himself, and give him an example of some way that he's done. Did you ever get sideways with anybody? He's just laying the bait out there. Objection, sir. Relevance. Like I said, he should have stayed away from this from the start. Just that as soon as he opened that door, just you close it. Objection, sir. Relevance. Makes no difference whether I have a job or not.
Way there while you're doing door-to-door sales?
No, sir.
Okay. Well,
And I object to what Miss Craven said right there. I do not need an attorney, nor can the court force me to have an attorney. I am myself. I am the beneficiary.
Now, he's mixing the I am myself. I think he's got that from me. I've used that a lot. But the beneficiary thing is coming from, I think, other Crow guests that are working with the trust law stuff. And he is the beneficiary. He's right. Now, what they're trying to do is they're trying to treat him not as the beneficiary. And what he's trying to do is he's trying to assert that he is the beneficiary. That's why he keeps sticking that in their face. Because if he's the beneficiary, he's got superior claim to everything involving his account. It means these people have no rights to this account, which they're trying to do. They're trying to tug on his account and get money from his account. And he's trying to claim, I'm the beneficiary. I have superior claim to this account.
you are exactly right. You have a right to represent.
You are exactly right. That's really where it should have stopped. He told him, you're exactly right, and then he tries to spin it off a little bit, and he tries to regain jurisdiction. This is very slick what this judge is doing. He's going to say, you have a right to represent yourself. Remember, only lawyers represent people, other people. If you're a man or a woman, you can't represent yourself. How can you represent yourself? You are yourself. And that's what Richard's going to state here.
Represent yourself.
I do not represent myself. It is impossible for me to represent myself, sir. I am myself.
See the judge laughing? He knows. Listen, he's not laughing at Richard as being like some kind of clown. He knows Richard knows the game. He knows Richard called him on the BS. Listen, dude, I'm not representing myself, sir. I am myself. That's why he's laughing. Listen, the judge is actually getting a kick out of this because they're used to marching the monkeys through the court, okay? And he's used to just steamrolling the monkeys. And some of these guys actually like it when you know a little bit and you can stand up for yourself. Listen, that's what that chuckle's about. He knows, this guy knows exactly what we're doing to him. He knows the game.
That's just the term of art in these.
That's just a term of art. No, 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 it's not a term of art. It's an attempt to gain jurisdiction. It's not a term of art. So the judge is trying to blow it off like, not, it's just something we say. No, it's not. Words have meanings.
These criminal cases, so you're pro se is what they say.
Oh, so you're pro se. Right now, he's trying to regain jurisdiction again. Richard took the, you're representing yourself away from him. So then he's trying to bring jurisdiction back in by stating you're pro se. Remember what I said about pro se? Pro se is to, there's God, man, government, and corporations. So when they call you pro se, they're bringing you all the way down from second level from man. They're trying to bring you under government because the attorney, the dirtball bar association member, the scumbag, he's low man on the totem pole. Okay, he's way down there. So when they call you pro se, they're putting you on that attorney's level. They're diminishing your status of a man. That's why he immediately rolled into this pro se thing.
I'm well aware of the legalese, sir. It's impossible for me to represent myself, seeing as I am the beneficiary. I myself.
So what that tells me is that when we do put your case on the trial docket, in the event that you don't come up with a plea bargain and the state does not dismiss the charge, you will be in the courtroom speaking for yourself.
There it goes. He just told him, listen, well, see what that tells me. What he's telling you is, listen, man, I know you know what's going on in this little scheme. You're very competent to be yourself in this matter. He's letting them know, listen, I know you get it, and I know you're competent. I know you're not some crazy nutter.
Now, I will have Ms. Craven on the side in case you should happen to have any legal questions.
He's still trying to rope him in jurisdiction-wise. Listen, I'm going to have Ms. Craven on the sideline. Did they want to attach her to him and try and rope him into their jurisdiction?
But she will not at all interfere in the case.
Because if he agrees to have her, he's basically stating that he's the defendant and that he needs counsel. So he's trying to rope him into this.
Unless you ask her to. Do you understand?
Do you understand? Do you understand why he said it? Do you understand? He's looking for agreement. Because if Richard says, yes, I understand, well, he's saying, yes, you're right, Judge. Basically, you do have jurisdiction, and you can appoint her as my attorney. In other words, you can make these decisions for me. So this is another one. You got to say, sir, I object. No, I don't understand. And then you counter it.
No, sir, I object.
Bang, he hit it right there. No, sir, I object.
I do not need an attorney. It is impossible for me to represent myself.
Look at the judge smiling. Look at that smile on his face. He gets it. He's having fun with this, the judge. He knows that Richard's a player, basically. Richard's a player in this game. He's not one of the monkeys. He's got a player on his hands. He knows it. He's not used to seeing this. So that's why that smile. I said the judge is actually a pretty decent guy. He gets it. He knows that Richard gets it, and he's actually getting a kick out of it.
Myself, it is impossible for me to be pro se. The court cannot force me to be pro se. I am myself. I am the beneficiary.
The court cannot force me to be pro se. Brilliant statement. He's stating, that's all right. I'm going to hold my status up here as man. I'm going to stay right below God. I'm going to still hold my status here as man. I don't want to come down to the slums with the attorneys. I'm going to stay up here. He's exactly right.
Jerry.
Well, we'll see how that all shakes out.
Well, we'll see how that all shakes out. The judge is having, like I said, he's having a good time with this. He knows Richard's a player. He knows the game.
We're not going to have a trial unless you decide to have a trial, before the court, meaning a non-jury trial, and we do it via Zoom.
Unless you decide to have a trial before the court, a non-jury trial. Absolutely not. Objection, sir. Under both state and federal constitutions, I have a right to trial by jury. I have a right to invoke common law. Any matter of $20 or more for whatever reason, you have a right to trial by jury, and this is a criminal case, so he still has a right to trial by jury. That's under Amendment 6 of the federal Constitution, and depending on what state he's in, it's in his state constitution too. So no, you don't want to trial with him without a jury, because then the man in the black robe, he now becomes judge and jury. And listen, it's a closed game, and you're not one of them, because really what you have here is he's a bar association member, the prosecutor's a bar association member, and whatever assistant prosecutors they have working over there, they're bar association members. They're both on the same team. Their first allegiance is to the court. It's not, it's not to justice. It's to the court and then to the bar association. So I would object to that objection, sir. No, if there is probable cause before this court, verified probable cause and supported by an affidavit, and we do have a trial in this matter, sir, we're going to have a trial before a jury. We're going to have a jury trial.
It's going to be some months before we end up with a jury trial in the courtroom.
Okay.
So I trust that he is competent, Ms. Craven. I'm going to make that independent judgment.
I trust that he is competent, Miss Craven. Look at her mouth. The schoolmarm's mouth, her jaw dropped. I don't think she's got a clue what's going on. I don't think she knows anything about this trust stuff. I just think she's clueless. He knows. Listen, he's telling you right there. He's told you a couple times that Richard's competent. He knows Richard's a player. You've seen him laughing. He knows that Richard knows the game. He knows he's competent.
All right, I just want the court to be aware of my concern and that I would request the evaluation.
Objection, sir. Miss Craven has no jurisdiction, no legal standing, no personal knowledge of any matter. And, sir, for the record, I need Miss Craven to shut her mouth. Miss Craven is testifying against me. If Miss Craven wants to testify against me, because that's what she's doing, the schoolmarm's testifying against him. If the schoolmarm wants to testify against him, the schoolmarm needs to be put under oath and go on the record. Do not let these attorneys speak against you without being on oath. And you're going to hear this the guy, the little dirtball in the right-hand corner, he's going to speak later. That's another one. Objection. Soon as these attorneys open their mouth, objection, sir. Even under their rules, per Rule 602, you could either cite the rule or just cite the facts of it that these people, Miss Craven, has no personal knowledge of this matter, and she's not to speak against me. She's not going to testify against me. If Miss Craven has anything to say about me, Miss Craven's going to need to go under oath so that I could hold Miss Craven accountable for everything that comes out of her mouth.
For competence. But if the court is finding him competent, then I'm okay with that, sir.
The problem I have is I don't think he's going to submit to an examination, and I think it will be too oppressive to throw him in jail until he does submit. So
I don't think he's going to submit. They can't make you do anything. And I think the judge, tongue-in-cheek, no intention of throwing him in jail. That was just basically, he's just trying to put a little fear in Richard. He's hoping he can scare Richard a little bit. That judge has no authority to throw Richard in jail because he won't take a mental competency hearing. It's an absurd claim.
I'm just not going to do that. So, Mr. Arterburn, we're going to put your case on a trial dock probably sometime in the fall. Be mindful of that date. We will want your...
Objection, sir. I don't see any probable cause here, sir. Sir, before you put my trial on the docket, I need you... Can you state the probable cause that's brought this trial here? Remember, probable cause means a crime. It's a commission of a crime. It's how you get warrants issued. In order, like I give an example. If a cop see me run a red light and he couldn't get me, but he knew where I lived, and he went to a judge and asked for a warrant to come write me a ticket or to arrest me, the judge would laugh at him because the judge knows that you're talking about codes and that there's no victim in any matter, so the judge would never issue a warrant in such a matter. So this is a criminal matter, and the only thing I think Richard missed here is this judge wants to put this on the jury docket. No, sir. I need you to state the probable cause of this matter before we're going to do anything. Because probable cause means, remember, in any criminal matter, there's got to be an injured party. You got to have an injured party. Richard did not injure the state. You can't injure Mickey Mouse or Donald Duck. All right? And Mickey Mouse and Donald Duck and the state are not going to come into court and testify. So if there's no injured party, there's no cause of action before this court, and there's no probable cause.
Should appear in court for that. If for some reason we're still not having court, we'll let you know, and we'll do it again as we're doing today. Do you understand?
Objection, sir. Hear him giving an out, though. He's saying, do you understand? In other words, he's saying if the court's still closed, we're going to do one of these bogus Zoom meetings. Objection, sir. That's a violation of. I have a right to be in an open court with witnesses, sir. I don't. I do not. I do not understand. You know, I decline that offer, sir. If this matter ever goes to trial, we're going to do it in public in an open court where I can have as many witnesses as I can bring in. Basically, no, we're not good. This is. I could call these star chambers. This is a star chamber. In other words, thank God this is recorded. Richard could put this out here. But this is a star chamber. This is something I would have never agreed to do this. I want to be in an open public court. If you can't have an open public court, then I guess I can't come into your little charade of a hearing. So I would never agree to these Zoom meetings.
And we'll talk about it.
Yes, sir, I do.
All right. Anything else you want to say or put on the record, Mr. Atterburn?
Now, that was a mistake. He said, yes, sir. I agree to that. I would have never agreed to that. Objection, sir. Like I said, I'm not going to agree to having a Zoom meeting.
Yes, sir. A couple things. For the third time,
He's going to throw something out of here that he definitely got this from me. I got it from Robert Fox, but he got this from me. I stole it from Robert Fox. I'll tell you where I got it from because I thought it was brilliant. And what you're going to see here is Richard's got affidavits in this matter. Now, that's your most powerful tool. These people can't rebut your affidavits. The little scorm arm in the upper corner and this little noodle down here, this guy down in the lower right corner, they can't rebut Richard's affidavits. But right now, Richard's affidavits technically are hearsay because he doesn't, even though he's got them submitted to the court, they're not on the court record yet. Okay, it confuses people. Even though he's got them submitted into the court docket, they're technically not on the court record yet till he enters them. And one way you enter them, you would read them, or you use this little trick that I stole off Robert Fox that he basically stole off me. I brought this up on Crow Show. He's going to give you a statement, and what he's going to do is he's going to take his affidavit and he's going to place it on the court record. It's actually a pretty brilliant thing that he did here.
I do object to the court trying to force me to have an attorney. I do not need an attorney. I am myself. I am the beneficiary. It is impossible for me to represent myself. And I understand that I am to accurately state the facts. And if I inaccurately state the facts, I may be subject to penalties of perjury under the laws of the United States of America. Having qualified my testimony as in the affidavit that I have filed here today, I hereby state for the record that everything in my affidavit is the truth, the whole truth, and nothing but the truth. So help me God.
Bang, mic drop. That's exactly a mic drop there. He just took his out-of-court testimony, his affidavit, and he just submitted it on the record. Now watch things start to change here a little bit. It's going to get a little gray and foggy here. They're going to make it sound like, well, we're going to still push for this, we're going to still push for that. But what you're going to see is they're going to, now that he's basically showed this judge he's competent, they're going to try, they got to move this matter out of this court. And now they got a problem because now what you just watched was Richard putting his affidavits into the court docket, actually on the court docket. Now they have a problem. Now they're going to sort of, they're never going to come out and admit that they're going to walk away from this or they're going to drop this. And you know they're going to say, well, we have no intention of dropping this. No, and then things just sort of fade away. But what you just watched was a very powerful thing he just did. He just got his affidavits on the court record. Now watch where this other woman will pop up and she'll state, well, then this matter has to be moved out of this court because it was only here for this mental hearing evaluation thing. Oh, how about that? No, what you just watched is those affidavits were just a bomb drop that were dropped.
Okay. Now you have a right to remain silent, and you can choose to remain silent, and it's your right, and no one's going to complain about that. Or you're free to speak when the time comes. So anything else, Mr. Arterburn?
No, sir, Your Honor. I appreciate you. Thank you.
So the way we're going to do it is Ms. Craven will be in the courtroom. The jury will not know that she's your lawyer, but
Objection, sir. Miss Craven is not my attorney, not my lawyer.
we're going to have her there just because the law kind of requires us to be.
Objection, sir. What evidence do you have that that law has any applicability to me? Who made this law, sir? Oh, the legislature. Sir, objection, sir. Unless you bring the legislature in to testify and explain how that law applies to me, sir, that's inadmissible here. You're assuming facts that are not in evidence. This judge is assuming facts that are not in evidence. He's referencing laws that he's yet to prove apply to Richard. And I don't blame Richard. Listen, this is the stuff they do to you. They try and steamroll you. And once you've got steamrolled a few times, you figure this stuff out.
Cautious, but you will not have to have any communication with her nor call on her for any purpose. Do you understand?
Do you understand? Hear what he's always saying? Do you understand? He's always looking for agreement from Richard. He needs agreement from Richard.
Yes, sir, I do understand, but she does not even need to be there, sir. I do not need her there at all. There is no reason for her to be there. She is not there to. I am not pro se. The court cannot force me to be pro se.
I am not pro se, and the court cannot force me to be pro se. Bingo. Okay. In other words, you cannot take my status from man and bring me down to the dumps with the attorneys. No, I'm gonna stick with the designation the Creator gave me. I'm not gonna go lower myself to where the attorneys are.
I myself, I am the beneficiary. It is impossible for me to represent myself.
May I say something, Your Honor?
Yes, ma'am.
Objection, sir. She's got no jurisdiction, no legal standing, no personal knowledge of any matter. If Miss Craven wants to say anything in this matter, sir, I'm going to demand you put her on under oath, because I cannot have a person speaking against me, because what she's doing is she's testifying against him in this matter. This dirtball attorney up here is testifying against him, and with no liability. Got to get her on the record. Don't let these dirtball attorneys speak against you.
Ms. Aton with the county attorney's office has put a statement out on the chat saying that this is a Court 7 case. If it's not going to remain on the mental health docket, then perhaps the county attorney will want to be setting it back into Court 7. I just wanted to draw your attention.
Perhaps the county attorney may be wanting to set it back. Perhaps. There's a lot of perhaps here, because basically those affidavits they just did a hell of a perhaps. So that's why all of a sudden you see this one popping up. They're trying to get it out of this court.
Attention to that.
I had forgotten about that, and Mr.
Yes, sir.
Arterburn, although I might
Oh, I forgot about that. Oh, wait a minute. I was just ready to set this for trial here. Jeez, I forgot about that.
find this case very interesting. And
Though I find this case very interesting. Oh, I'm sure he did. That's why you seen him smiling. He wanted to hear this case because he knows Richard's a player. He wanted to see how this was going to play out.
kind of look forward to dealing with it.
I kind of look forward to dealing with it. How many times you heard a judge say that? I kind of look forward to dealing with this. Like I said, he's used to dealing with the monkeys that they just parade through there. And now he's got somebody that's not a monkey. He's got a player here.
In the courtroom. This case is not from my court, so it will be transferred
This case is not for my court.
to the County Court 7.
Understandable, sir. Understandable.
That is Judge
Well-
Elizabeth Earl, so my coordinator will communicate with the coordinator from that court, and they'll put you on the docket there.
See, I would eject all that. Put me on the docket. Like I said, if you're going to put me on the docket, hold on, sir. We first need to establish that this court has personal and subject matter jurisdiction in this matter. And, sir, I don't see it anywhere. I don't see any evidence that there's personal and subject matter jurisdiction in this matter. And, in fact, you haven't stated probable cause yet. There is no probable cause. When you're involved with the state and there's no injured party, there's no probable cause in this matter.
Yes, sir.
Already assigned to Court 7, Judge. So I'll just email Court 7, let them know that they need to set it on a jury trial docket.
Okay?
Your Honor, may I interject?
Thank you.
Yes.
It's Eric Yoon for the state judge.
Objection, sir. Now, this guy's going to speak for the state, this attorney. The state's a fiction. It's corporate fiction. Objection, sir. This little dweeb is speaking for himself. This little bar association member, this dirtball, is speaking for himself. Objection, sir. The state factually is a corporate fiction. Mr. Hume, or whatever his name is not speaking for a corporate fiction, sir. This is fraud. That's like me coming in, sir, and speaking for Mickey Mouse. He's speaking for himself. Sir, if Mr. Hume wants to speak in this matter, I'm going to need Mr. Hume put under oath so that I may hold Mr. Hume accountable for everything that comes out of his mouth.
I just want to put for the record, Judge, that the state echoes
Objection. Mr. Hume, continue to speak for the state.
defense, Elsie Craven's concerns about competency. Your Honor, I believe that a motion and an order has already been signed.
Here's what's going on here, okay? Richard just got his affidavits into the court case. So this guy's worried now. This big attorney, big bar attorney, he's now shook because he knows he can't answer these affidavits. He can't rebut those affidavits. As long as Richard stands on his affidavits, we're done deal. He's going to slam dunk this guy. So this guy, his last play is to hold on to this competency hearing, to try and get him to get him deemed incompetent, so that they can take one of their bar association buddies and attach him to Richard. He's sinking fast, this guy. He's trying to throw a boat anchor onto Richard and pull him down.
For a competency eval in this case, Judge. You know, I mean, I think the state will, you know, obviously follow whatever findings that you have, Judge, if you believe he's competent. But
Please, Judge, we're going to get our ass kicked. This guy's going to smoke us, Judge. He's got affidavits. Can you please help us, Judge? We really need this competency hearing. We got to get one of our buddies attached to Richard so that we can pull him down to our level.
But I think the state's position is that given that current motion and order, Judge, that Mr. Arterburn should submit himself to a competency evaluation.
He should submit himself to a competency evaluation. We believe Mr. Richard should run into the fire and burn himself. This is the dumbest statement I've heard. These are bar association members. How much money they spend on education? You know, these guys are supposed to know what they're doing. That he should submit himself. How stupid does he think Richard is that he's going to run into the fire and burn himself?
Evaluation before we do anything else on this case. And if he doesn't want to submit to it out in the community, then, Judge, I think the warrant should be issued so that in custody examination can be done.
A warrant for there's no freaking way this judge is going to issue a warrant to do anything like that. Remember, warrants can only issue under probable cause. In other words, an affiant must swear under oath or affirmation that Richard's committed a crime or is about to commit a crime. There's no way this judge is going to issue a warrant to have Richard take an exam. This little dweeb down here, he's sinking fast. He knows he's going to get his ass kicked now. There's affidavits that are in this case. He don't want to fight anymore, basically. He don't want to give up. He's so arrogant, they still don't want to give up, but he knows he's in a bad position right now because this judge knows that Richard's not incompetent. So now we're talking about Richard's affidavits are going to come to the surface.
Done. Judge, at this time, I don't think the state is entertaining any disposition related to dismissal.
At this time, we're not entertaining any disposition. Bull. They're entertaining it.
And because of that, with the ongoing competency concerns, Judge, I think the state's position is that an evaluation should be done before we set it on a trial setting, Judge.
Now remember that this judge, before we set a trial setting, see, this guy doesn't want to go to trial now. The judge already said, listen, a few times that Richard's competent. He knows Richard's competent. And look, what you're seeing here is this attorney's begging this other bar member, listen, he's telling him, listen, man, we're going down with this guy. We need you to give us this mental evaluation thing so we can attach our dirtball to Richard.
On the record now, I'm voiding the order for an examination.
The judge is a decent guy. I'm voiding the order for the examination. He's saying, I'm not going to do it. I know this guy's a player, and I'm not going to, even though it's a corrupt system, every now and then you do get some decent judges. And listen, when this guy was smiling, that was a good sign for Richard, because that's telling you that he sort of likes Richard. He likes that Richard knows the game. And like I said, as corrupt as their system is, he doesn't want to cut Richard's legs off. He's going to give Richard the shot to take these guys down.
I don't know what paperwork someone will need to send me for that, if any.
I don't know what paperwork they'd have to send me, if any. The judge is saying, listen, I know this guy's competent. I don't need you people to send me anything. I'm telling you he's competent.
Mr. Arterburn, I am not going to order that. However, you need to understand that Judge Earl may choose to do whatever she chooses with your case. So I wish you well.
Thank you, Your Honor. You have a good day.
Thank you, Judge.
Thank you, Mr. Yu.
So what you watched there, that was awesome. I mean, he did a phenomenal job, especially the Richard Fox thing.
The reason I love using StreamYard, well, that's easy.
Especially the Robert Fox thing, when he got the Robert Fox thing in there, that was phenomenal. I mean, that was beautiful. So he held his ground. So don't get rattled. I mean, it's good. The only good thing this helped him with is I could tell he had like his notes set on the side, like he had his bullet points, what he was going to hit. So listen, I think Richard did a phenomenal job, and but I just wanted to do a little evaluation just to show you the stuff that they're doing.